depends on the nature of the harm and whether or not it's to the extent that it's necessary to recover the damages caused by that harm. You may have a scenario, just for example, let's say you have a non-compete with an employee, and the non-compete is done in such a way that it's enforceable. It was drafted well, and the employee signed it. So the employee leaves the company and immediately begins to violate the non-compete. And somehow the employer finds out rather quickly that this is happening. But the employer hasn't lost any major contracts or hasn't lost any contracts because of it. Sometimes it happens where the former employee will try and steal a client, and the client will talk to the employer and say, hey, your former employee is trying to steal your business. And if there hasn't been either any type of monetary harm to that point, or at least a great deal of harm, then you may be able to just solve the problem by issuing a cease and desist and say, we know what you're doing. And typically those are drafted by attorneys. And then we point out the provisions in the non-compete that were signed that are being violated, and then state that if you continue in this course of action, then we will go ahead and avail ourselves of all remedies, including but not limited to filing suit to enforce that, which either could be through an injunction. I could also sue for monetary damages. You could actually too, there's tortious interference with contracts. So a third party that's aware that there's a non-compete and agrees to do business with the former employee, knowing there's the non-compete, they have exposure to a lawsuit. So that's just one example, but a lot of times you can rectify it by pointing out to the other side that you know what they're doing. You know what they're doing, and you know what they're doing is illegal, and you point out the reasons why they're illegal, and you tell them to cease and desist from that activity. If that doesn't stop, then obviously then you can go ahead and go through the pre-litigation issues that have been discussed, or you can file suit and you can ask for injunctive relief, which basically says to the other party, you ask for a court order saying you have to stop what you're doing. You're harming the other business, and then you can sue for monetary damages as long as you can prove those in court, that the company has been damaged by someone else's or some other party's intentional breach of either a contract or by some other type of tort. Then the business could recover from that. But before any of that takes place, a business really has to have either their own lawyer or go to outside counsel and to determine if there actually is some type of legitimate count that could be filed if there needed to be, and there was actually some type of violation, and then B, what to do about it. And like I said, you may start off, and usually does, with some type of letter if there's been some type of damages, and maybe those could be negotiated and said, look, this is, you owe us X amount of dollars, but if you stop and you pay us 75% of that, we will let it go this time, but we need to be compensated and you need to pay the attorney's fees. So they're all different kinds of routes, but that's what the experienced attorney is for.